Good morning, everyone, and welcome to our second seminar of the course of Smart Cities, Artificial Intelligence, and the Digital Transformation Law. This is the second part of our set of seminars and workshops relating to the course, but open to the public. Yesterday, we had a very interesting discussion about fake news, conspiracy theories, disinformation, and misinformation. And this morning, we will talk about the AI Act. In particular, we will see a general overview of this very relevant regulation in the European Union. And then a more specific focus on banned practices and AI literacy according to such regulation will follow. Once again, just as I did yesterday, I would like to ask if any student from the course need to be identified for attendance reasons, because as I told you, this can count as one attending class in case you need it. And so if you wish to proceed, so please do so now. Otherwise, I think we can start with our seminar. So the first contribution will be the one of Professor Giovanni Ziccardi. Then my intervention will follow, and the seminar will be closed by our colleague and PhD student Eyul Erva, which I will introduce to you later. So once again, thank you very much for being with us, and I leave the floor to Professor Giovanni Ziccardi. Thank you.
Thank you, Desideria. Thank you also for your great work you are doing and you did this semester in this course. I will only present 5 points of the AI Act that, in my opinion, are very important, because it was probably the most complex and the most important regulation in the past political legislature of the European Union. So the idea to have an AI Act in Europe is not only an interesting legal target that is very important, but it is also a very complex norm to study and to understand. And so in this first 30 minutes, I will try to identify 5 points that, in my opinion, are very important. The first one is the birth of the AI Act. The second one is the purpose or the purposes of the AI Act. The third one is to understand how the European Union values all the values that came out from the Second World War, from the international charts and international documents of the European Union are inside the AI Act, and they describe a sort of artificial intelligence made in Europe or in a European way. Then we will see if there is a definition of artificial intelligence in the AI Act. That is very important, because you know that jurists are very interested in definitions, because definitions can help to draw the lines and the borders of the application of the norms. And then the risk approach the pyramid of risks, that this was a choice of the European Union, that it was a choice similar to the one that started the GDPR to interpret technology as a risk issue. Then I will leave to Desideria for the general introduction to all the most important parts of the AI Act, and then I will leave for the last part regarding digital literacy and the importance of the knowledge of these notions, and Eylul Erva will discuss about this. I prepared only 10 slides, so I will be very quick. The birth of the AI Act, it's very interesting. You probably know that the official journal of the European Union of the 12th of July was the last official journal of the former governance of the European Union. So it was mandatory to publish the AI Act on that journal just before the new governance and the European elections. It was important because this norm is a norm that started with discussion and with the first drafts in the spring of 2021. So after 3 years of work, and after the advent of ChatGPT from the October of 2022 and March of 2023, you know that, for example, the Italian Data Protection Authority blocked ChatGPT in Italy. It was the March of 2023. In these 3 years, artificial intelligence became popular in the world. A lot of companies started to increment the business and the investments in AI. So it became a topic that started a lot of discussions about how to regulate this technology. And you probably know that the United States of America and China decided to take several different approaches to regulate AI. United States, the land of the big companies that are developing AI, and the land of the platforms, decided to put at the center of the regulation the idea of consumer or user of a platform, and in many cases decided not to regulate several parts of this technology. On China, on the other side, they saw the artificial intelligence as a technology strictly connected to the national security and the idea of control and surveillance, especially of citizens. In this world where China and the United States have the monopoly of the production of AI, Europe decided to regulate AI, putting at the center of the regulation the natural person, the dignity, the non-discrimination, the data protection, and the privacy of the person. So in the 12th of July of 2024, we finally had on the official journal of the European Union the regulation called Artificial Intelligence Act. It came into force the 1st of August, but we will see that several parts of the regulation will be enforced from next year, from February of next year till 2029. So the European Union knows that it's a very complex legal framework, and so we will need several years to put all the norms down on the ground and to create all the architecture needed to create this European legal framework of artificial intelligence. In the first part of the Act, you can see the purposes and the purpose of the AI Act. The purpose of this regulation is to improve the functioning of the internal market. So it is it was thought also as a strategy to make the internal European Union market of AI a boost to this market by laying down a uniform legal framework, in particular for development, the placing on the market, the putting into service and the use of artificial intelligence systems in the Union. Here is the important part: in accordance with Union values, to promote the uptake of human-centric and trustworthy artificial intelligence. So, in an European idea, the AI must be human-centric and trustworthy. And this legal framework wants to ensure a high level of protection of health, safety, fundamental rights, as enshrined in the Charter of Fundamental Rights of the European Union. Which are these values? We will see in a next slide, but you see, the protection of democracy, the respect of the rule of law, the environmental protection, the protection against harmful effects of AI systems in the Union, and to support innovation. The idea is also to help the European Union market to eliminate restrictions on the development of AI. You know that the European Union has a lot of problems of investing in AI, of find some real budget to ask them to promote the development of AI. AI is a very expensive technology, and all the big companies started to put money in AI about 15 years ago. But this framework does not want to, to block innovation, but also tries to eliminate restrictions and also to make the starting of and the development of AI also in the European Union. The third point I would like to share with you, which are the European Union values that are at the basis of this legal framework, is the protection of natural persons, the protection of democracy, the protection of the respect of the law and the protection of the rule of law, and the environmental protection. The idea is to make the European Union as a leader in the uptake of trustworthy AI. Fourth point, have we got a definition of artificial intelligence in the AI Act? Yes and no. Here I put the Italian definition for all the persons that speak Italian language, but also the definition in English. Yes and no, because the European legislator decided not to put a too focused definition and a too specific definition of AI, but the preference was for the definition of AI system. And as you can see, is a very wide and generic definition. An AI system means a machine-based system, so you need a machine, you need a computer, that is designed to operate with varying levels of autonomy. So there is the idea that AI can have autonomy, and so that can act independently from a natural person, and that may exhibit adaptiveness after deployment. So you put on the market an AI, and this AI will adapt to the society, to the place where is deployed. and that for explicit or implicit objectives infers from the input it receives. So the artificial intelligence is a technology that infers from the input of specific data how to generate outputs. And here you can see 4 families of AI in this generic definition. AI that can generate predictions. So this is the world of the predictive AI. And so, for example, the artificial intelligence used to make predictions in agriculture, for example, or also in crime, you know, the idea to prevent crimes. But there is also, for example, the anticipatory compliance, so to predict risks and IT incidents in companies or in other entities. The AI that can generate content, and this is the generative AI, ChatGPT, for example, or HeyGen are the most famous AI that can generate content. Recommendation, so AI that can suggest you something to do. Or decisions, this is the idea of the robo-judge and the AI that can take a decision. For example, in the banking and insurance field, these 2 types of AI are very, very interesting. And all these predictions, content, recommendation, or decision can influence physical or virtual environments. So this is very interesting because on one side, the European legislator decided not to put a specific definition of AI. You see, with deep learning, machine learning, large language models. In other parts of the regulation, there are some technical issues, but decided for a very generic definition. There are other interesting definitions in the first part of the regulation. Probably the most interesting one is deployer, because they decided also to keep the wording in English, also in the Italian version, and also in other versions of the regulation in other languages. Deployer is a body that uses an AI system under the authority, and it could be a natural or legal person, the public authority, agency. You know that to deploy is an expression used in the military field. It means to put all the soldiers and the troops on the ground. This is the idea that an entity, like an organization, like for example a municipality, can buy the core of the artificial intelligence and the technology, and then deploy it for the citizens, in the how to say, for the citizens in the place. It's very interesting also the series of definition concerning data that you can use with artificial intelligence systems. And for example, you find the definition of training data, validation data set, testing data, input data, and biometric data. These are the types of data you can find in the regulation, but that you can also typically find in a common AI system. Very interesting, in my opinion, are the training data, because the correct training process of an AI system is very important for the quality of the output, but also the validation and testing process, especially testing before placing on the market the product, is fundamental. Very interesting, the definition of emotion recognition system, that it's one of the most advanced use of AI today, is the idea to use AI to analyze your face in a picture, in a photo, or in a video, to infer emotions or intentions, for example, of a consumer. And I spoiler a part of Desideria. The emotion recognition system is one of the families that are banned by the AI Act, but only on the workplace and on education frameworks. So you see that is left the possibility to use such an important technology of emotion recognition in marketing, for example, or for the profiling of consumers. After the ChatGPT case in 2022, 2023, you find also the definition of general purpose AI model. That is an AI that is trained with a large amount of data and that is capable to perform in a competent way a wide range of distinct tasks, regardless the way the model is placed on the market. It's very interesting because a sort of general purpose AI that is not the general AI, that is another thing. This is the general purpose AI model. It's very important because it's one of the most common used today types of AI. And this is my last slide, and then I will leave the floor to Desideria. The legal framework of the European Union decided to take a risk-based approach, exactly as in the GDPR and in another norm. So, as Desideria will tell you, we can easily divide the AI systems in several categories. The most important are the unacceptable risk category and the high risk category, because the first one is banned, the second one is permitted in the European Union, but you need to put on the ground a checklist of compliance activities. I will send this brief introduction to Desideria, my slides. She will put them on Ariel for our students. Now I quit my sharing of the screen. And now in the core of the seminar, Desideria and Erva will, enter in the deep of the AI Act, discussing with you the most important issues. Thank you, Desideria.
Thank you very much, Professor.
I leave you the room and the floor, and have a good lesson.
Thank you very much. I will just, I'm just trying to share my screen. I don't know if I have the powers to do so.
Yes, I see that you are a co-organizer, so try to...
Okay.
I will name you organizer. Wait, assegno organizzatore. Okay, so now you are the boss of the meeting.
I have all the powers.
Yes, you've got like the Avengers. You've got superpowers. So I think that you can share your screen without problems.
Okay. I am really sorry. Let's see. Okay.
Ma metti non consentire.
Okay. Okay, sorry for that. I think that this morning my my personal computer was a little bit lazy, so I just apologize for that. So good morning again to everyone, and thank you, Professor Ziccardi, for your very useful introduction and for giving us some significant definitions that will be useful in the following parts of the seminar. So first of all, let me explain to you why did we decide to focus specifically on prohibited artificial intelligence practices, and then later on AI literacy. We did so because the regulation, so the AI Act, was designed and is created with a very, let's say, diluted implementation over time. As Professor Ziccardi already mentioned, it entered into force on the 1st of August 2024 and was published on the official Gazette on the 12th of May. But then the first fulfillments we do have regard exactly prohibited artificial intelligence practices and the necessary AI literacy path that all European states need to follow, that will be implemented within February of 2025. So let's say these are the first relevant fulfillments that the regulation state. So this is what I was talking about. So the AI Act, its scope is to lay down harmonized rules on artificial intelligence, and that is why the European Union institutions decided to operate with the tool of a regulation instead of a directive. We saw this briefly, but it's important to give some context to what is following. So the context, as you know, is usually given by the recitals of a regulation. So the purpose, the main purpose of the AI is to draw a uniform legal framework for the development, placing on the market, and putting into service and use of artificial intelligence systems. But how? Those need to be in accordance with Union values in order for the European Union to promote human-centric and trustworthy artificial intelligence. These are key principles according to the regulation. So as also Professor Ziccardi was saying, for the European Union, the most important aspects for artificial intelligence systems are for them to be human-centric, so based on a very strict attention on individuals, on their freedoms and on their rights, and artificial intelligence that can be deemed trustworthy. All of this also in the support of innovation. So as you can understand, the balance is already and will be in the next years quite challenging. Recital 5 states immediately that artificial intelligences may also generate risks and cause harms to public interests and fundamental rights that are protected by Union law. Afterwards, in recital 28, the regulation goes more specific and states that aside from the many beneficial uses of artificial intelligence systems, these can also be misused and provide powerful tools for exploitative, manipulative, social control practices. Already in the context of the recitals, the regulation makes very clear that such practices can be and are particularly harmful and abusive and should be therefore prohibited. And why is that? Because first of all, they contradict the union values. The recitals then move forward to stating that the regulation, this is a standard practice, should be without prejudice to the existing legal framework, in particularly those regarding data protection, consumer protection, fundamental rights, employment, protection of workers, and product safety. Another side note important for us to remember is that the AI Act, as I was saying at the very beginning, should support innovation, should respect freedom of science, and should not undermine research and development of activity. Of course, once again, this is part of a very important balance the European institutions had to do between granting the development of research, but at the same time granting the safety of freedoms and rights of individuals. So recital 25 clarifies that it is necessary to exclude from the scope of the regulation those AI systems and models that are specifically developed and put into service for the sole purpose of scientific research and development. Going more into the, let's say, into the interesting part of this contribution, the recitals immediately clarify also that the whole structure will be based on a risk-based approach. So recital 26 clarifies that in order to introduce a proportionate and effective set of binding rules for AI systems, a clearly defined risk-based approach should be followed. And it is necessary to prohibit certain absolutely unacceptable practices, to lay down requirements for high-risk AI systems and obligations for relevant operators. And at the very end, transparency obligation for certain AI systems. The European Union institutions are not new to this kind of approach. As a matter of fact, the risk-based approach was also implemented in the GDPR, so in Regulation 679 of 2016. even though let's say the only section in which this is mentioned is Article 24 that I pasted here at the end of the slide in order for you to benefit from its text. What is the risk-based approach, and how shall the European institution implement it and make it applicable? So recital 27 clarifies that while the risk-based approach is the basis for a proportionate and effective set of binding rules, it is also important to recall the 2019 ethic guidelines for trustworthy AI developed by the independent AI high-level expert group, which was appointed by the Commission. And in particular, in those guidelines, the group of experts developed 7 non-binding ethical principles. So this again is intended to help balancing the key principle of having artificial intelligence systems that are trustworthy and human-centric. We will now see the 7 principles. So this is the document the recital was referring to. So recital 27. This is the high-level expert group on artificial intelligence, which was set up by the European Commission. And actually, it's quite interesting that this document was made public in 2019, which clarifies that for the European Union, the attention to the ethics is and was very significant. This is a first charter on the ethics guidelines set up by the group of experts, which explains how the document on ethics is organized. There is a first introduction that defines how to ensure that an AI system is trustworthy. And this is through having a lawful artificial intelligence, an ethical artificial intelligence, and a robust artificial intelligence. Chapter 1 lays down the foundation of a trustworthy AI, stating 4 general ethical principles. First of all, the respect for human autonomy. Second of all, the prevention of harm, fairness, and explicability. After that, next step is to understand how to build a trustworthy artificial intelligence. And in order to do so, there are 7 key requirements that the group of experts underlined, which are human agency and oversight, technical robustness and safety, privacy and data governance, transparency, diversity, non-discrimination and fairness, societal and environmental well-being, and finally accountability. And this shall happen through both technical methods and non-technical methods. Finally, since the trustworthy of an AI system must be granted for its whole life cycle, an assessment of trustworthy artificial intelligence must be done, and this must be tailored to each and every specific AI application. So this is the list of the seven, let's say, the seven most significant principles, requirements in order for an AI system to be considered ethical. The list is non-exhaustive. This screen was taken from the AI high-level expert group document I was mentioning before. And I think it is quite interesting from my perspective that the first requirement that it was undertaken is human agency and oversight. So from my perspective, it is indeed quite interesting that still in evaluating the ethics of an artificial intelligence system, the human oversight is still the most important, one of the most important and relevant requirements. The second requirement, as we saw, is the technical robustness. This includes resilience to various kinds of attacks and securities, privacy and data governance, transparency. So as I was mentioning, it is very important to grant transparency for the whole life cycle of artificial intelligences that are not banned, and this includes traceability, explainability, and communication. It is important to keep in mind the aspects of diversity, non-discrimination, and fairness, including the avoidance of unfair biases. We will see this later, the accessibility and universal design, and the stakeholder participation. Then societal and environmental well-being and accountability that somehow relates to the first requirement of human oversight, and which includes auditability, minimization of the risks, reporting of negative impacts, and this shall be put in place for the whole life cycle of the system. So this figure is figure 3 is the ways in which a trustworthy AI can be built throughout the system's entire life cycles. So it's a continuous connection and communication between the use, which needs to be evaluated, the analysis, the redesign in case something needs to be corrected, and development. And all of these 7 requirements are interrelated between them and shall be continuously evaluated and addressed throughout the whole life system. So let's go back to our pyramid. We already saw it briefly. So at the top, we have the unacceptable risks. They do include all prohibited practices that are included in Article 5. Then going from the top to the bottom, we find high risk systems, limited risk systems, and minimal risk systems. So the first, the unacceptable risk are practices that are absolutely prohibited, except for some exemptions that we will see later. High-risk systems need to comply with specific conformity assessments. Limited risk needs to comply with some transparency obligations. Instead, at the bottom, there are the minimal risks that don't need to fulfill any specific obligation unless they wish to do so with code of conducts and so on. Of course, as you can imagine, fines for non-compliance with the AI Act in the specific regard of highlighting specific risks related to each and every artificial intelligence system are quite severe, and they somehow they recall the sanctioning systems, the sanctioning structure that was already put in place with the GDPR. So as you can see up, for example, for non-compliance to Article 5, which is the one relating to unacceptable risks and prohibited practices, the fine is up to 35 million or 7% of global annual turnover, which feels quite significant. So going to in more in the specific to the prohibited practices that lie on the concept of an acceptable risk, we see immediately in Article 1 of the AI Act that the regulation makes clear that it lays down prohibitions of certain AI practices. So first of all, I believe it is quite useful to highlight some relevant keywords. So Article 5 is structured in a way that it makes quite clear which one of the AI systems and AI practices shall be deemed prohibited. In letter A, so in Article 5, paragraph 1, letter A, we have the placing on the market, the putting into service, and the use of systems that deploy subliminal techniques, purposely manipulative or deceptive techniques, with the objectives of distorting behaviors of people or impairing their ability to make an informed decision, which can cause, of course, significant harm. The second keyword we may keep in mind is the concept of exploiting vulnerabilities. So the second AI practice, the second family of AI practice that shall be prohibited are those that exploit any of the vulnerability of people, of a specific group or of an individual, due to their age, disability, or to a specific social or economic situation, with the objective or consequence of distorting their behavior. The third family relates to the concept of evaluation, classification. So this recalls the image of social scoring, social sorting that we will see just in a minute. So evaluation or classification based on social behavior of certain individuals, of a certain group of people, inferred or predicted personal or personality traits, leading to one of these two scopes. So one is a detrimental or unfavorable treatment in social contexts that are absolutely unrelated to the context in which the data was originally generated. And second, unjustified or disproportionate, consequences for a certain social behavior. So these are just the first three families. Then we have the family stated in Article 5, paragraph 1, letter D, of the concept of predictive justice. So it is prohibited the use of artificial intelligence systems that predict the risk of a natural person committing a criminal offense based solely on profiling that person based on their personality traits and characteristics. Here we do have the first exemption, so it is clarified that it shall not apply if these kind of systems are needed to support human assessment in the involvement of a person in a criminal activity, but such criminal activities shall be based on objective and verifiable facts. So there shall be criminal investigation already put in place. The family stated in letter E that regards facial recognition database through the untargeted scraping of facial images. Family of prohibited practices as of letter F that use artificial intelligence systems to infer emotions. This is what Professor Ziccardi was referring to earlier. In the specific areas of workplace and education institutions. We have then the family stated as of letter G. And here the keyword is the use of biometric categorization that categorize people based on their race, political opinion, that they can deduce from biometric elements aspects relating to their race, to their political opinions, to trade union membership, religious or philosophical belief, and so on. The family as of letter H, so real-time remote biometric identification in public spaces that are strictly prohibited unless for specific reasons, for example, the search for victims of abduction, trafficking in human beings, sexual exploitation, or the search for missing people. Another exemption is in case of terrorist attack, or for the localization or identification of people suspected of having committed a criminal offense in those for those specific crimes that are listed in Annex 2, that are punished with a minimum of 4 years imprisonment. But we will see this in more detail in just one minute. So this was just an overview to give you a sense of the timing. So as we were saying, the prohibitions, so anything that relates to Article 5 will get into force, will enter into force 6 months later. So as we were saying at the beginning, this will happen approximately in February 2025. So going back to each and every of the family of banned practices we saw. So the first one is gives the sense of artificial intelligence systems that use subliminal techniques to purposely manipulate, distort the people's behavior. And I highlighted the word objective because here it's very important to underline the idea of mens rea and intent. So in order for such practices to be deemed prohibited, it is important for them to use such subliminal techniques to somehow manipulate a person consciousness, to distort their behavior and to impair their ability to make informed decision. Of course, this causing significant harms. The reference here, as you may imagine, is what happened with the Cambridge Analytica case. So as the data scientist Christopher Wiley stated during the trial, it was actually before the trial, it was made clear that the company Cambridge Analytica had illegally obtained all the Facebook information of almost 87 million people and used it to build psychological profile of voters. So this is something that the European Union fears, and this is the reason why we have the first family of banned practice. There are also some references in the recitals. So recital 29 makes clear that these kinds of AI systems deploy subliminal components that most of the time people cannot even perceive. So as those stimuli that are beyond human perception, or other manipulative or deceptive techniques that somehow subvert or impair a person's autonomy, its capability of making decisions, of deciding freely in ways that people are not even consciously aware of, or where they are actually aware of that can still be deceived or are not able to control or to resist them. the same recital also clarifies that such prohibitions should not affect all those lawful practices in the context of medical treatment, for example, psychological treatment of mental diseases, physical rehabilitation, and in addition, all those common and legitimate commercial practices, for example, in the field of advertising. So these are two very relevant exemptions. Moving to our second family of prohibited artificial intelligence practices, we do have those artificial intelligence systems that exploit any of the vulnerabilities of people, relating or connecting to age, disability, social or economic situation that may materially distort their behavior and cause a significant harm. So the reference once again is recital 29, which specifies that specific social or economic situation are likely to make these vulnerable people even more vulnerable to exploitation, such as people living in extreme poverty, ethnic or religious minorities. And once again, the exemption is lawful practices in the context of medical treatment. The third family we saw is the one of letter C of paragraph 1 of Article 5. And is related to all those artificial intelligence systems connected to the evaluation or classification of people based on their social behavior, which is inferred. So it means deriving from all sorts of collected data or predicted, which recall the idea of a predictive assessment of personal characteristics. And these must be put in place for one of the two scopes. So one is detrimental or unfavorable treatment in social contexts that are completely unrelated to the context in which such data was collected. For example, a very simple example for this is the denied access to public housing in case a person is caused an accident. So it's two completely different contexts that shouldn't be related the one to the other. And the second scope is treatments that are unfavorable and unjustified or disproportionate to their social behavior. This is very strictly linked to the idea of social scoring. So it is actually recital 31 that states that such AI systems do evaluate and classify classify people on the basis of data points related to social behavior in multiple and diverse contexts. And this, of course, is related to the fear of the European Union institutions to replicate what somehow is already happening in China, for example. So where there is a social credit system according to which behaviors which are considered to be positive lead to rewards, while behaviors that are connected to negative outcomes may lead to punishments. And here I pasted some images that, in my opinion, are quite significant. So the fear of the institution are those of having a sort of continuously social scoring that let's say can be identified on top of each of us. And another I mean relevant indication about this topic is the Black Mirror episode Nosedive. I don't know if you have seen it, but anyway, it is set in a world where people can rate each other from 1 to 5 stars, basically using their smartphone. And they can do so for every interaction they have that can impact significantly their social and economic status. So the lady here in the picture is the main character, and she is quite obsessed with her ratings. So during the episode, she does literally anything she can to elevate them, but this, of course, turns out to be quite a disaster. And anyway, I did spoil the episode in case you haven't seen it, but I believe it is quite significant in this topic. So this, as I was saying, the example, the typical example we make for treatments that derive from behaviors in social contexts that are completely unrelated the one to the other is, for example, denying access to public housing or to credits in case of an accident, or in case of a behavior which is deemed to be, let's say, not positive. Letter D, so going back to our families of prohibited practices, relates to the idea of predictive justice, which is which is something that the European institution also do fear, and this actually is something that is quite common in the United States system. So here the aim is to prohibit all kinds of artificial intelligence systems that aim to assess or predict the risk of people committing a criminal offense, only based on profiling these people based on their personality traits, their characteristics. The exemption, as we saw, is when this is needed to support a human assessment in order to understand the involvement of a person in a criminal activity. So recital 42 from this perspective is quite clear in stating that people should never be judged on AI predictor behavior based on their profiling or on traits such as nationality, place of birth, residence, number of children, level of debt, and type of car, all these kind of elements. And this can also happen with risk assessments carried out with regard to individuals in order to assess the likelihood of their offending or to predict the occurrence of a potential criminal offense. The family related to in letter E refers to the idea of artificial intelligence systems that create or expand facial recognition database through the untargeted scraping of facial images. And this can happen both from the internet or from closed circuit TV. From now on, let's say the family that are considered by the regulation make reference to the idea of the Big Brother of 1984 of George Orwell. So that is most probably the fear that was faced. So the idea of being constantly watched, surveilled against individuals' freedoms and rights. The reference to such family can be found in recital number 43. That makes clear that those systems that create or expand the facial recognition database through the untargeted scraping of facial images shall be prohibited. At the same time, it makes clear that there are some exemptions. For example, the virtual try-on. As you know, this became very big during the pandemic, where companies started granting consumers with the possibility of virtually trying on first was makeup, then glasses, jewelry, and then finally clothes. So this is still an exemption to this family of prohibited practices. Letter F is the one that was also mentioned during Professor Ziccardi's contribution. Prohibits the use of artificial intelligence systems aiming at inferring emotions of people in workplaces or in education context, except once again where the use of such systems is intended for medical or safety reasons. And again, here, the fear is to replicate somehow some practices that are already put in place in China. Of course, why, I mean, if you think about the reasons why the European institution could have done such a choice, it is quite evident that the risk of mistake, of misunderstand emotions is very high. And in such sensitive and important areas such as workplace and schools, it is quite important to have these values safeguarded. Like, just imagine how this does not happen with the most obvious, let's say, obvious emotions. So happiness, sadness, anger, surprise. At the level of development of AI systems today, most probably these kind of emotions can be, let's say, easily, but can be understood and identified. But just imagine less obvious emotions, such as the difference between disappointment or boredom, or calm, a person being calm from a person being tired. I mean, this is something that that makes a great difference, and so that's the reason why it was absolutely prohibited in the areas of workplace and schools. There is an exemption. So recital 18 clarifies that it does not include physical states, and does not include detection of readily apparent expression, gesture, or movements. If you go to our point of reference in the regulation for all definitions, which is Article 3, you find the definition of emotion recognition system, which means any AI system for the purpose of identifying or inferring emotions or intentions of people on the basis of their biometric data. The recital 44 moves forward and is quite clear in saying that there are serious concerns about the scientific basis of AI systems aiming to identify or infer emotions. For now, I will add. And why is that? Because such AI systems may lead to discriminatory or intrusive outcomes. So that's the reason why they are still they are prohibited. Letter G. This is now the start of the family of prohibitions relating to biometric categorization. So biometric categorization, categorization based on biometric data. So anything that relates to facial images, dactyloscopic data, fingerprints, letter G declares that they are the use of biometric categorization systems that categorized based on biometric data of people to deduce or infer their race, political opinions, trade union membership, religious or philosophical beliefs, sex life, or sexual orientation are banned. The exemption in this case is in the area of in the only area of law enforcement. And once again, if we go to our definitions, we see in Article 3.34 what we do mean by biometric data, what we do mean by biometric identification, so the automated recognition of physical, psychological, behavioral, human features for the purpose of establishing the identity of a natural person by comparing biometric data of that specific individual to biometric data of individuals that are already stored in a larger database. Biometric verification, so the automated one-to-one verification, including, for example, the authentication of the identity of a person by comparing their biometric data to previously biometric data granted by the same person. And the reference in the recital, I have to admit, are many, so I just selected the most relevant one. So recital 16 makes clear what shall not be included in the prohibitions of letter G, so that they shall not include biometric categorization systems that are ancillary feature linked to other commercial services. These are not and also are not included, for example, filters categorizing facial or body features used on online marketplace, allowing the consumer to preview the display. So this is the virtual try-on we were mentioning earlier, to display the product on him or herself and help the consumer to make the purchase decision. Recital 30 that basically state the ban of biometric categorization as we already saw it. And the only exemption that is accepted here is for reason and in the area of law enforcement. According to point 46 of Article 3, law enforcement is quite a broad definition, so it means activity carried out by law enforcement authorities or on their behalf for the prevention, investigation, detection, or prosecution of criminal offenses or the execution of criminal penalties, including safeguarding against and preventing threats to public security. We do have here another family of prohibited practices related to biometric identification, according to letter H of paragraph 1 of Article 5. So this is the use of real-time remote biometric identification, especially in spaces that are accessible to the public. So this is prohibited, this is banned, unless in so far as such use is strictly necessary for one of the objectives. We saw it earlier. So, for example, the search for missing people, for terroristic reasons, for all the offenses that are listed in Annex 2 that are punished in any case in each member state with a period of detention of at least 4 years imprisonment. So here again, it's quite interesting from my perspective that the whole regulation is constructed in a way that you can jump back and forward, but with all the same as it happens frequently. But I think that in the complexity of this regulation, everything makes quite sense. Professor Ziccardi always say that the AI Act is most probably one of the most complex EU regulation we do have by now, but it is still quite coherent. So this is why I recall most always the same articles, because once again we go back to our definitions. So we do have in the same area of definitions everything that is needed in order to interpret correctly letter H of paragraph 1 of Article 5. So this is the point 40, point 41, so biometric categorization system, remote biometric identification system. I will read this. So it means an AI system for the purpose of identifying people without their active involvement. So typically at a distance through the comparison of a person's biometric data with the biometric data contained in a reference database. Real-time remote biometric identification system, which is a remote biometric identification system whereby the capturing of the data, so the initial capturing of the data, the comparison and the identification all occur without a significant delay. It relies not only to instant identification, but also limited short delays in order to avoid possible circumvention. And then point 43, the post-remote biometric identification system. So a remote biometric identification system other than, so anything that is different from a real-time remote biometric identification system. Here there is the reference to recital 17. So AI system that so a remote biometric identification system is a system intended for the identification of a person without their active involvement, typically at a distance, through the comparison of a person's biometric data with the biometric data contained in a reference database. So the important aspect here is that such remote biometric identification normally are used to perceive multiple persons at the same time, so simultaneously. Instead, in case of real-time systems, the capturing, the initial capturing of the biometric data, its comparison and its identification occur instantaneously, or let's say near instantaneously, or in any event without a significant delay. It is also clarified in this recital the difference between live or near live material for real-time systems. As we were already mentioning, the post systems. Here there is instead the reference of what is commonly understood according to the regulation for publicly accessible spaces. So any physical space that is acceptable to an undetermined number of persons, irrespective of whether the space in question is privately or publicly owned, and irrespective of the activity for which the space may be used. So here there is a very long list of what it is believed to be a space accessible to the public. So shop, restaurants, cafe, banks, professional activities, swimming pools, gyms, stadiums, airports, railway stations, cinemas, theater, parks, and so on. Here again, recital 32 defines and clarifies that the use of AI systems for real-time remote biometric identification in these spaces is to be considered particularly intrusive for both the rights and freedoms of people. And this to the extent that it may affect the private life of a large part of population. So evoking a feeling of constant surveillance that limits the exercise of freedom of people, or freedom of assembly, for example, and other fundamental rights. But that is not only the reason why this is particularly harmful and dangerous. It is also because technical inaccuracies of AI systems intended for these remote biometric identification can lead to biases results and entail to discriminatory effects. Actually, on this, there is a very interesting documentary on this, and in general on some of the technical inaccuracies of AI systems. As of today, there is a very interesting documentary on Netflix. If I'm not mistaken, it is called Coded Biases. And it's quite interesting if you are interested in this topic. And actually recital 34 recalls what we were saying, that it shall be deemed lawful only for reasons of law enforcement. And we saw them. I mean, some of the reasons were the search for certain victims of crime, threats to life, to physical safety, and the localization and identification of perpetrators and suspects of the criminal offenses listed in Annex 2. I will show it to you in 1 second. Another reason why the family of another reason why there can be an exemption to the prohibition of letter H is, for example, a threat to critical infrastructure, border controls, immigration, or asylum reasons. In any case, this is quite interesting. The use of real-time remote biometric identification systems for these specific reasons, so in these specific exemptions, in publicly accessible spaces, so solely for the purpose of law enforcement, should be, however, subject to an explicit and specific authorization by a judicial authority or by an independent administrative authority of each member state whose decision is then binding. So no decision producing an adverse legal effect. This is a guarantee that still is granted as a general framework, should be taken based only on the output of remote biometric identification systems. So not only shall there be a specific authorization by a judicial authority, but also in case each member state has decided to expressly provide the possibility to authorize such use of prohibited practices stated in letter H, shall and is invited to create a set of detailed rules of national law. In order to carry out these all the requirements as of this section of the regulation, the relevant market surveillance authority and the National Data Protection Authority in each state should be notified of each use of real-time biometric identification system. As I was mentioning, I would just like to show you quickly the list of criminal offenses as of Annex 2. So these are the cases in which there are exemptions to the prohibited practices. So where real-time biometric identification systems can be somehow, and with the limitations we saw, still be used. So they are quite serious criminal offenses: trafficking in human beings, sexual exploitation of children, trafficking in weapons, murders, trades in human organs, kidnapping, seizure of aircraft, ships, rapes, serious environmental crimes, sabotage, participation in criminal organizations, and so on. So we at the end, actually, Article 5 seems to be quite disorganized, and if we shall make a note, it makes no sense for us to have a paragraph 2 that still talks about real-time remote biometric identification, but this, of course, is just a formal side note. But anyway, at the end of paragraph 1, where all the banned and prohibited practices are listed, there is paragraph 2 that still talks about remote biometric identification systems in spaces accessible to the public. And in this disposition, it is stated that its use for the purposes of law enforcement for any of the scopes we saw shall be deployed for the purposes set out only to confirm the identity of specifically targeted individuals, and it shall take into account the following elements. So the nature of the situation giving right to the possible use, and this relates to the seriousness, probability, and scale of the harm that would be caused if the system were not used, and B, the consequence of the use of the system for the rights and freedoms of all persons concerned. Finally, and this is the end of my presentation. Sorry, I just realized I was quite long on this. There are the last paragraphs, so paragraphs 5, 6, 7, and 8. That close, let's say, the chapter on banned practices, and clarifies that member states may decide to provide in their national law all detailed rules relating to banned practices. That national surveillance market authorities and national data protection authorities of member states that have been notified of the use of real-time biometric identification systems, as we saw earlier, shall submit to the Commission annual reports on such use, and the European Commission shall be collaborative in this sense, so shall provide member states with templates, with guidelines, and so on. So it shall publish these annual reports based on aggregated data that were collected in each member states. And of course, they shall not include sensitive operational data or data relating to somehow law enforcement activities. And finally, the last paragraph of this very long Article 5 state that these articles shall not affect the prohibition that apply where an AI practice infringes other union law. So from my perspective, let's say a lot of attention was granted by the European bodies in making sure that most of the most significant and relevant and dangerous practice of artificial intelligences and future developments of them are blocked within the European Union territory. So with this, I ended my presentation, and I apologize with Eylul because I think I was a little bit long. Let me just, okay. Okay. So I will now leave the floor to my colleague, Eylul Ervakin. She is a PhD student, and maybe she will briefly introduce herself and her activity within our chair and our team. And as I was mentioning earlier, she will talk about the other very relevant fulfillment that shall be, let's say, shall be completed within the next couple of months, and most probably within February 2025. So the whole world of AI literacy. So thank you very much.
Thank you, Desideria. Do you hear me? Yeah. Also, can I share my screen?
Yes.
I'm still seeing your desktop.
I'm sorry. as I was saying earlier, somehow
Why is that? Okay, let me try to take over the current share.
I don't know why it's not, is it now going? I don't know why.
Now my presentation should be on the screen. Do you see it? Because I shared, yeah, Article 4 of the.
Yes, we see.
Okay, thank you. Yeah, hello everyone. Thank you, Desideria, for your kind introduction and your entire lesson on prohibited activities in the EU AI Act. And I am Eylül Erbakın, and I'm a PhD researcher. I'm in my final year, and I'm I'm researching artificial intelligence and copyright law. Today, I will dive into the Article 4, which deals with AI literacy, and we will cover how EU AI Act truly entails and what does it mean for AI deployers or providers. Excuse me, just okay. As I said, AI literacy is a provision under Article 4 in AI Act, and it says providers and deployers of AI systems shall take measures to ensure to their best extent a sufficient level of AI literacy. This is the general scope of the obligation. Providers of deployers should take some measures, and the target of these measures are either staff or other persons dealing with the operations and use of AI systems on their behalf. So staffs can mean employees or individuals directly employed or contracted by the organization, and other persons means, for example, external contractors, consultants, or partners involved in the maintenance of AI systems. And also there is an emphasis, according to me, it's quite important, to their best extent. So it's also included in the scope of the obligation, but we will dive into how AI providers and deployers can fulfill their obligation to their best extent. So what does it mean, a sufficient level of AI literacy? These are the issues that pop up in our mind when we first read the Article 4. And the purpose of the purpose of the obligation, we can understand the purpose of the obligation from the definition part of the AI Act. Article 3, paragraph 56 describes the AI literacy, and it says AI literacy means skills, knowledge, understanding that providers, deployers, and affected persons, and taking into their respective rights and obligations, and to make an informed deployment of AI systems. This is really important in order to understand the scope and the purpose of the obligation. Also, gaining awareness about opportunities and risks of AI and eliminate the possible harm it can cause, it's also important. This is a very generic definition. It says a lot. I mean, there are a lot of important terms that we need to really understand. Otherwise, it will be just an HR issue, just just a training. So measures to promote AI literacy. So at the end, organizations should provide specialized training for risks of AI. So this is the summary of the AI literacy. Organizations, providers, and deployers of AI systems should provide training. However, what my session will emphasize is going to be the algorithmic bias and fairness, because if we neglect the real meaning of AI literacy, as I said, it will be going to be like an HR training that improve the capability of using AI of the staff and the employers. But AI literacy is not just about using AI, and it's not just about the technical aspects, how to use AI, how to integrate it into workload, or how to generate more creative ideas, how to effectively use it. The AI, it's of course a part of it, but it's not just about it. And I didn't say it in the beginning, and it's a good opportunity to say it now. AI literacy, the provision of Article 4, is a provision that for the first time coming out as a legal obligation. So this is not just a code of conduct, or this is not just promoting some good practices. This is a legal obligation. So we need to understand this issue, because it also supports the idea of ethical and the legal use of AI. So when we consider any AI models, if it is a really ethical or legal compliant with all the EU AI Act regulation, we should also look at the AI literacy provision. So in this regard, this is very important provision now. In the past, for example, in Audiovisual Media Services Directive, there is an obligation for the member states to promote media literacy. So AI literacy makes me think of media literacy as well. Also on the video sharing platform, they have a responsibility to take measures to for effective media literacy. But AI literacy is a bit more than that, because it has much more consequences according to the fundamental rights of the users. So we will be discussing it in a while. As I said, the true AI literacy should really engage with AI systems capabilities and limitations, which the AI has it, obviously. This is all we know and we should be aware of. And risks like bias and misuse is the most important aspect that we should be aware of. And also there should be a culture where people feel empowered to question AI outputs responsibly. So as a outcome, Article 4 pushes organizations to tackle these issues in using AI literacy deeply. Let's go to some technical aspects of Article 4 of the EU AI Act. As you know, the whole EU AI Act will apply from 2026. This is regulated under Article 113 of AI Act. However, there are some earlier applications regarding some chapters, and Chapter 1 is one of them, and Article 4 is a part of Chapter 1, so it will apply from 2 February 2025, but according to recital 178, there is an encouragement of voluntary compliance. So providers of especially high-risk AI systems are encouraged to start to comply, but it's of course on a voluntary basis. But this is important because the consequences are really damaging on fundamental rights. So it's really important to start during the transitional period as well. And AI systems covered under Article 4, there is no specification of which AI systems are covered under Article 4, but we understand from the general reading of the AI Act, all AI systems are covered, of course, including high-risk AI systems and generative AI systems, or some limited risks like chatbots or recommendation engines. And also, while using HR tools or recruitment and evaluation, it should be taken into account. Yeah, now I want to move on with some examples of the bias of AI, because, as I said, the most important thing of AI literacy is to really understand the biases of AI. It really has. First example from Amazon AI recruitment tool. Some years ago, Amazon used an AI tool to choose the employers, and the hiring data consisted of some years of existing data, and the most of the employers were male. So the AI thinks that male is preferable and male employer is much successful, because which is why we hired them a lot more than women. So it penalized women. So this is a really good example of gender discrimination in AI. So it is doing it unconsciously. So AI literacy is knowing that there is a reinforcement of such biases existing in our society. And the second example comes from Microsoft Tay chatbot, and Microsoft used a chatbot, and it was trained on the existing Twitter data. And in a while, the chatbot becomes a racist because of the training data that it's used while machine learning. So Microsoft, of course, shut down the Tay immediately. But this is also the example of unmoderated public data. And also this one and the previous one, these are bias in data set and outcome. And also the bias can be in the outcome as well. For example, some online platforms censor some specific content, like pro-Palestine content. So this is also another bias in the algorithmic moderation system. So it silences activism reporting and marginalized voices. So this is also affecting the fundamental rights, such as freedom of expression. So Meta did it, for example. And another bias in output is the Apple credit card. Apple credit card algorithm offered lower credit limits to women compared to men. Again, because of the same reason that the algorithm was trained on a biased data. So the algorithm reflected the biases in financial decision making. So all of these examples are really important. And when I was preparing this session, I thought of myself that I should really focus on the bias aspect and the misuse of AI, because otherwise the technical capability of the AI is really not enough to understand the AI literacy. While you are prompting something on AI, or when you have an output, you should always be aware of it. And yeah, this is what I want to emphasize during this session. So in conclusion, Article 4 of EU AI Act really makes an important step in terms of AI literacy and understanding the limitations of AI. And it is for the first time a legal obligation for AI. And we will see if it really works, but I consider it as a really important and not non-necessary provision. Okay, thank you for listening to me.
Thank you very much for your contribution, Eylul. I don't know if any of you have some questions. As of for students, just as we did yesterday, we will upload our slides on Ariel, so on our platform. I will just leave a couple of seconds if in case somebody has a question. Otherwise, I thank you very much for being with us also this morning. I thank the external participants, and I wish good luck to the students that tomorrow have their final test. And if this is all, I think we can end our seminar. So yes, I think this is it. So thank you very much, everyone, and thank you again, Eylul, Erva, for participating.
Thank you so much, Desderia, and everything.
Okay. Bye-bye. Thank you.
Bye.